Chance. It's a virtual professional development program. And I believe we all have a lot to learn from this program. That's why we signed up. This program will cover two main topics, which will expose participants to the fundamentals of international commercial arbitration. So the first part of it will be a primer on the fundamentals and stages of an international arbitration proceeding. And the second will be the basic differences and forms of international commercial arbitration based on various sectors. I believe we all saw the poster and we've seen our distinguished panelists, but I'd like to introduce them to you one more time. We have Victoria St-Amour from Clifford Chance. She's a senior associate there. And then we have Alexis Foucard, who's a counsel at Clifford Chance as well. And then we have Tosin Murana, who's also an associate at Clifford Chance. We look forward to an engaging discussion. You can also put into the comment section your name and where you're joining us from, your law firm as well. Who knows? We can connect with you, yes, on LinkedIn or some other form of social media. Now, we'll move straight to our questions for today, our discussion. And we'll start with Victoria. Victoria, can you kindly tell us how you got into arbitration, specifically international commercial arbitration?
Yes, sure, Lauraine. Thank you very much for the introduction. Well, I suppose I started my journey in London when I first started university and did a law degree. And then quite soon after that, I started a training scheme with a different international law firm, also based in London. And it was during this process that I was first introduced to the world of arbitration. I spent about 6 months in the arbitration group, focusing on investment treaty arbitration. And so when it came to qualifying as a lawyer, I think I was quite set on going into the field of disputes generally, but litigation and arbitration in particular. But I also knew I wanted to do that abroad and didn't want to stay in London. And that's why I moved out here to Dubai, which is where I'm based now, and joined Clifford Chance. And that was just over 9 years ago now. And I've had the opportunity to work on a really broad range of disputes in that time. But more recently, I've been kind of focusing my practice area more and more on construction disputes, for which arbitration is very often the chosen dispute resolution method.
Interesting. So Victoria is doing more of construction. And what are you into, Tosin? How did you get into international commercial arbitration?
Thanks, Lauraine. So similar to Victoria, I also started my legal journey in the UK. So I was born in the UK, raised in the UK with a Nigerian background and often frequent Nigeria. And I secured a sort of legal training contract with Clifford Chance while I was at university, which is a process that allows you to qualify as an England and Wales solicitor. So as part of that training contract, you do various different rotations within different departments at the firm with a view to qualifying into one of those departments once you're done with the 2-year rotation. So I did, as part of my training contract, did finance, some corporate work, also litigation, dispute resolution, including arbitration and finance. And I realized quite soon that I was more suited to dispute resolution, litigation, arbitration. And I've been practicing in the team in Dubai now for about 2.5 years, but I've been in the firm for about 4.5 years now.
Interesting. That's a very diverse background. And how about you, Alexis?
Hi, everyone. So I was educated in France and the US. I'm qualified in Paris and New York. I do focus on arbitrations, and like Victoria, I do a lot of construction work, also mining and energy. I do claims between private businesses and also investor-state disputes. We'll talk about this a little bit more later today. And in terms of geographical focus, I do most of my cases are in Europe and Africa, more Africa than Europe lately. I am, in fact, the co-head of the Africa litigation practice at Clifford Chance. And one thing that I really enjoyed about arbitration when I started a little bit over 10 years ago was that it's global. So you really get to experience diverse clients, diverse opposing counsel, experts, witnesses, and it's something I'm still like not tired of. And in terms of just briefly my career, I started at US law firm Quinn Emanuel, litigation only law firm. I joined CC Clifford Chance in 2018. And after I started working, I had the privilege of working with our Casablanca office and the Africa group. And that was something that was a perfect match for me because my dad used to live in Morocco and I was going there all the time as a kid. So Morocco specifically and the African continent as a whole has always been special for me. In fact, I'm currently in Cape Town. I see that many of the attendees are from South Africa, from what I see in the chat. So I'm currently in Cape Town doing this webinar.
Yeah, I know there's a lot of interest in international arbitration on the African continent now, and South Africa, I believe, is not left out of the party. So before we move on, we'd like to take a solidarity message from Sarah Lulo. She's a rep from the International Senior Lawyers Project, and then we'll continue our discussion. Sarah, over to you.
Thank you, Lauraine, and thank you to all of our speakers. What a wonderful way to start this conversation, Lauraine. Thank you for that very personal touch. It's not often we get to hear a little bit about distinguished speakers, career paths, and personal interests. So thank you, everyone, for sharing. So good morning, good afternoon, good evening to everyone who's joining us today. It's wonderful to see all the comments in the chats and where people are dialing in from. On behalf of the International Senior Lawyers Project, ISLP, and our esteemed partner, the Institute for African Women in Law, IAWL, and Clifford Chance, I am really delighted to add my welcome to you to this discussion on the fundamentals of international commercial and investment arbitration. By way of background, I have the privilege of serving as the executive director of ISLP. In my earlier in my career, I also practiced international arbitration at another global law firm. So this topic is near and dear to me, and I was delighted to learn from IAWL that this was at the top of their list for opportunities for professional development offerings to their membership. So we're really delighted to be joined by the leading international arbitration group of Clifford Chance, which is really globally renowned, and to have a diverse set of perspectives to complement those represented among all of you in different jurisdictions that are joining us today. I want to add, before we get started, I just want to add special thanks to the entire IAWL leadership and team for really what has been outstanding partnership, collaboration, and wonderful stewardship and organization of this event. The incomparable Dr. Dawouni, Dr. Adadzi Koum, Lauraine, Esenam Eduse, Michael Gills. Thank you to all of you and to others who have really made this partnership get off to a great start with today's event. And of course, thank you to Victoria, to Alexis, and to Tosin for taking the time to share with us their practical expertise. And I'd be very remiss if I did not recognize and thank my colleague and friend, Glory Kinyua, ISLP's program associate based in Nairobi, who's really been the lead on the ISLP side in developing and leading this initiative with IAWL. So a little bit about ISLP. Our mission as a nonprofit organization is to provide pro bono legal support that promotes locally led efforts to promote the rule of law and foster inclusive, accountable development. Our work is always demand-driven and in partnership with organizations around the world that have direct knowledge and expertise in their respective jurisdictions and focus areas, and who are adept at identifying areas and ways in which we as ISLP can leverage international legal support to enhance and complement that local expertise. Central to our work is the engagement of leading international legal experts who generously volunteer their time and expertise. Among those are our guests and friends here from Clifford Chance. So we're really hoping that this provides all of us some practical insights into the practice of international arbitration and investment arbitration. We really see this as a very important area of international development. It's not lost on any of us, I'm sure, that an independent forum and mechanism for international dispute resolution is considered by many an essential element to facilitating and promoting international investment, ensuring that the contracting parties have some real say in determining how their disputes will be managed and resolved. And for legal practitioners, even if not international dispute specialists, this is a really critical area in which we should all be conversant so that we can better advise our clients on their legal options, from drafting clear and enforceable arbitration agreements and clauses and avoiding unnecessary and costly disputes over the meaning of the words that we choose, to knowing the practical fundamentals of the proceedings and process. At the end of this session, you will receive a feedback survey. We really want to hear from you. This is the first of what we anticipate will be many offerings that we, as ISLP, do in collaboration with IAWL, and we'd really like to hear from you what you thought worked well, what was most helpful. Are there other topics that you'd like to hear from international legal practitioners in partnership with local practitioners? Let us know what would be helpful to you in this ongoing series. So with that, we look forward to an engaging and thought-provoking discussion. Please add your questions in the chat or in the question and answer box, and we look forward to hearing from you afterwards as well. Thank you.
Thank you so much, Sarah. Thank you for that. And we'll move straight back to our conversation. Before we do that, I'd like to remind you to kindly put your details into the chat section. I mean, who knows? Your next appointment, arbitration appointment may come this, and don't take it lightly. I'll move straight to Victoria. And for me, when I discovered arbitration, it was just a little part of ADR. But when I moved straight into arbitration, I realized that there are so many niche areas, so many different parts. So I'd like Victoria to take us through or give us an overview of international arbitration and the place of international commercial arbitration in the arbitration puzzle. Please help us, Victoria.
Yeah, thanks, Lauraine. And I'm quite conscious here that we've got a very mixed audience today. And so I apologize if anything that I'm saying is very obvious to you, but I think I wanted to go back to basics here and just sort of outline where arbitration sits within the various forms of dispute resolution. And I think probably the easiest way to sum it up is just to say that arbitration is an option that the parties might choose to elect for, rather than sending their dispute to the national courts in their jurisdiction and going through a litigation process. So in this sense, the premise of arbitration is contractual. And what that means is that the relevant parties have to clearly agree that any disputes arising between them will be referred to arbitration. And this is usually done through an arbitration agreement. And that's a specific clause that's contained within the party's relevant contract. And I know Tosin's going to come on later to discuss some of the considerations that you might want to take into account when drafting an arbitration agreement. And so the sort of outcome of an arbitral process is the issuance of an award. And this award is akin to a judgment that you'd receive in a court process. And it's automatically final and binding. So maybe just to give a bit more of an overview of some of the features of arbitration, I thought it would be helpful to actually consider some of the reasons why you might want to choose arbitration as a dispute resolution method rather than litigation.
Right.
And I think these benefits can probably be neatly summed up by reference to something that Gary Bourne, who's a prominent arbitration practitioner, refers to as the 6 E's of arbitration. So I'll just take you through those 6 E's now, if that's okay. So first of all, arbitration is arguably more efficient than litigation. And this is probably a slightly contentious point, and it's probably not always the case. But the onus in arbitration is on the parties and the arbitrators to efficiently manage the procedure. And in this sense, I think arbitration can be more efficient than litigation because the procedure can be designed by the parties and the arbitral tribunal based on the specific needs of the parties and the characteristics of the dispute. So what I mean by that is you don't end up spending lots of time on parts of a process that you think are irrelevant. If you don't want to go through a particular section of the procedure, then you would just agree to skip that section and focus more on a later section in the process. So kind of tied to efficiency is the second factor, which is that arbitration is more expeditious than litigation. And obviously there's some overlap here, and the ability to tailor the process of arbitration will certainly assist in ensuring that arbitration is conducted quickly. But I think probably the main factor that increases the speed of arbitration when compared to litigation is the lack of appellate review. So what I mean by this is once you get your arbitration award, it's final and there's no option to appeal this as you would in litigation. So there's no sort of court of first instance, appeal court, and possible further levels of court. And this is quite important because, in some jurisdictions, this right of appeal to appeal the initial judgment you receive is even automatic. And that's the case, for example, here in the UAE, where I'm based. Often what we see is that there's a need to apply for permission to appeal a judgment. And that is the case in probably most jurisdictions around the world, including, I know, a number of African jurisdictions such as Kenya, Ghana, and South Africa. But even so, even if you do have to apply for permission to appeal, just the actual process of appeal in and of itself is going to add a lot of time to the dispute resolution process. And the other thing I just wanted to touch on in terms of the speed of the arbitration process is something that has come out in a lot of the modern international arbitration rules, which have been published by various institutions recently. And they've included a number of procedures which have really been designed to improve the speed and efficiency of arbitration. So two particular innovations. One of these is the emergency arbitrator process. So this process allows an emergency arbitrator to be appointed before the arbitration has even begun. And that appointment will take place within just one day. And that arbitrator will be required to issue within 2 weeks certain emergency interim measures, purely to just ensure that the status quo remains the same, the parties' rights are safeguarded until the dispute resolution process can proceed fully. And the second one of these processes is what's called the expedited procedure. And this is really tailored for smaller value disputes. So what the threshold depends on the rules that the parties have chosen. But it's usually for disputes that are lower in value than around 1 to 4 million US dollars. So still can be quite chunky disputes. And this procedure means that an award will be issued within 6 months. So you can be sure of quick access to justice. And just to flag as well, both of these processes are features of the Arbitration Foundation of Southern Africa, the Ghana Arbitration Centre rules, and the Nairobi Centre for International Arbitration rules as well. So moving on, the third factor that I wanted to touch on is this expert nature of arbitration. So arguably,
I think you might have to come up the last 3.
Oh yes, sure, that's fine. I can touch on them much more quickly.
Yeah.
So in terms of the expert nature of arbitration, arbitration allows you to choose your decision maker. So the parties themselves are choosing the arbitrators. And you can choose somebody that has particular expertise in the subject matter, or that's qualified in a particular jurisdiction, or that has experience in a particular geographic region. So that's a great advantage. The fourth reason is that arbitration is arguably more even-handed. And I think this is actually something that Sarah already touched on. It doesn't assume that you're going to send a dispute to the kind of local courts, and that there might be a sort of home advantage for one party. Instead, you've got the benefit of an independent, neutral tribunal. I will just spend a little bit more time on this one, which is that arbitration leads to very enforceable awards. So you might have heard of the New York Convention, but this is a convention that's in place to outline the process for the enforcement of arbitration awards globally. And about 170 countries have now acceded to this convention, including, I think, around 40 countries in Africa. And the main benefit of this convention is that it ensures that you can enforce an award of any member country in any other member country with very minimal difficulty. And I'll leave it there in the interest of time.
Thank you so much, Victoria. I'm sure those who would like to learn more concerning what you spoke about will connect with you after this session for more information. Now we'll move on to Tosin, and we'd like to find out, given Victoria's explanation of what international commercial arbitration is, what are some additional qualifications and skills that the lawyer needs to practice in that area? And I'd just like to add that we have people on here who are non-lawyers who are also interested in international arbitration, and we know that they can also practice as well. So what qualifications and skills do they need? And I'll just add that, could you kindly tell us, based on your experience, the soft skills that we'll also need in addition to the actual skills that we'll need?
Thanks, Lauraine. So if you are already a qualified lawyer, you don't necessarily need any specific qualifications to work in the arbitration space. However, having certain accreditations from chartered institutions such as the Chartered Institute of Arbitrators can be quite highly regarded. More generally, as a disputes lawyer, someone who practices dispute resolution, creativity is quite key, especially if you're the one that will be having to sort of come up with unique legal arguments. Another key skill is the ability to take in a lot of information, because arbitration often involves reviewing a large amount of factual information and documents. In addition to that as well, having an understanding of some of the procedural rules of major arbitral institutions. I think Vicky mentioned a few which relate to Africa. Some other international ones include the ICC, the LCIA. That can also be very helpful for effective practice, having an awareness of what these rules include. It also helps if you're working on cross-border matters to be able to conduct cross-border legal research, as international arbitration will often involve at least a basic understanding of the legal systems and practices of the various different jurisdictions that are involved. And another skill is organization, as there's a number of procedural elements to keep track of in an arbitration. So being able to stay on top of deadlines and organizing a big team, including lawyers, experts, and the arbitrators themselves, can be quite important. And another more general skill as well is language skills, as that can be quite beneficial to help you to set you apart, given that international arbitration will often involve parties from various different countries and jurisdictions. So proficiency in multiple languages can be a significant asset. And it can also be generally quite useful to do courses in broader areas which may relate to commercial disputes, such as negotiation, mediation. I myself recently did a course in mediation, and that was really helpful to understand how to break down some of the key commercial drivers behind disputes, how to interact with commercial parties, and just allows you to be more privy to what parties are considering in these sort of disputes, which can really help to give you an edge in any arbitration. litigation. And some arbitrators, if you're acting as the arbitrator, can even be appointed at times to help parties with their settlement discussions, etc. So having the skills of negotiation can be quite helpful in that respect. Moving on now to soft skills. Some of the key soft skills I would say would be active listening, being able to understand the needs and concerns of the clients and the various parties that are involved, and oral advocacy, honing in that skill as well, effective communication and being able to present arguments quite persuasively, including responding to arbitrators' questions with confidence and clarity, and also linking in to what I had mentioned about language skills, etc. More broadly, though, cultural sensitivity and adaptability. So being quite open-minded and having the ability to adjust to various different cultural backgrounds can be extremely helpful, and understanding the nuances of how your case might be approached by the different parties and the arbitrators from these diverse regions can really assist. And finally, just being able to manage one's emotions and understanding the emotions of others can also help to help facilitate the process in the arbitration, given that dispute resolution can be quite adversarial.
Thank you so much, Tosin. I think I'd like to add to yours general people skills, because in arbitration, you're really dealing with the people, much less in litigation where you don't have to really deal with the witnesses and all those people directly. In arbitration, you might have to deal with a lot of people more, even in the settlement process, and you want to ensure that you are able to relate with them well before, during, and after the process. Now we'll move on to ask another question for Alexis. And we know that you've had extensive experience in international arbitration, investment arbitration, litigation, and you're also a lecturer in international dispute resolution. Please give us an overview of the international arbitration proceeding or the process. If an arbitration is to start, where does it start from? How does it end?
Thank you. You make me blush. The one thing I want to add, by the way, to what's just been said is that I like to tell my students, since you talked about my lecturing, that being an arbitration lawyer is sometimes akin to being a wedding planner. It's all about coordinating the various actors, from the clients to the arbitrators, including the fact witnesses, the expert witnesses, and so on. Anyways, but when it comes to the stages of arbitration, in the interest of time and simplicity, I will take ICC arbitration as a reference point. Keep in mind that other institutions might have slightly differing approaches, but the fundamentals remain the same. And like Victoria, I apologize if some of what I'm about to say is too basic. This is to make sure everyone can follow, whether you have pre-existing arbitration experience or not. So if we can now project, the slide that I shared earlier on. Great. So an arbitration starts with a request for arbitration, obviously. It's not a very formal submission, at least in ICC arbitration. It doesn't have to be very long, and that's the first thing to keep in mind when you're drafting a request for arbitration. Less is more, because at the point of submitting your request for arbitration, you don't know the full extent of the dispute. You don't know what the opponent will say, how they will argue their case. So it's better to keep your request for arbitration short. It's something that I sometimes see as a common mistake of a request for arbitration that's too long, and that's showing too many cards, if you like. Once you file your request for arbitration, in ICC arbitration, you have 30 days, the respondent or respondents have 30 days to file their answer, possibly including a counterclaim. That's what you can see here, the second box. You can get an extension of 30 days, meaning you will have 60 days in total if you nominate an arbitrator, in the event that you're dealing with a three-arbitrator tribunal in the arbitration agreement, or if you take steps towards the nomination of the tribunal. So that's a first tip to have in mind. You don't have to comply with a 30-day deadline in the ICC rules if you make a move towards arbitral tribunal constitution. This takes us to the third step, which is the constitution of the arbitral tribunal. And here I want to emphasize how important it is to pick the right arbitrator. In most cases, you have 3 arbitrators. If the parties' agreement doesn't specify, the ICC court will appoint a sole arbitrator unless it considers that a dispute requires 3 arbitrators, typically if the dispute is too complex. But most agreements, most arbitration agreements, in my experience, provide for 3 arbitrator tribunals. And so as claimant or respondent, choosing the right arbitrator is key. One thing that I try to do when I'm claimant, so meaning I have to put forward my arbitrator selection choice first, is to think of what type of arbitrator the other side will likely appoint. And then think about the possible chair arbitrator, right? Because what you want is an arbitral tribunal where the arbitrator you've nominated, whether as claimant or respondent, will be the most influential on the chair, because you only need a majority to get an award in favor of your client as counsel. It's okay if the other side's arbitrator issues dissent. That's actually generally a sign that your appointee was more convincing towards the chair. So you have to really try to put yourself in the shoes of the other side. If you're claimant or if you're respondent, you have the benefit of knowing which arbitrator has been selected by the claimant, and you can adjust on that basis. I mean, we've just talked about language skills, for instance. That's an important thing. If you anticipate that the chair might speak a certain language, and if you see that the other side's arbitrator is speaking the same language as the chair on the top of English, you might want to consider this, because you want the other side arbitrator to be able to have one-on-one conversation with the chair that your arbitrator will not understand. Just a very, very, like practical tip. Think about that. Same with, legal background, whether you pick a professor or you pick someone who's like very much of a practitioner or both. These are all criteria to consider when nominating your arbitrator. Okay, moving on now to the terms of reference. This is a specificity of ICC arbitration. We don't have much time, but one thing to keep in mind is that it's where you have to crystallize, where your claims or defenses are crystallized. So it's not something to be taken lightly. Then you move on to the timetable and the procedural rules. It's usually on the occasion of what we call the case management conference, which is an initial meeting between the parties and the recently constituted tribunal. Usually during that case management conference, you discuss the procedural rules and the timetable. Here again, it's important to be very careful in the timetable you negotiate with the other side, or you try to get from the arbitral tribunal if there's no agreement between the parties on the timetable. You sometimes can win or lose an arbitration based on procedural rules, such as document production, which is the next box, usually taking place after a first exchange of submission, so after the statement of claim and the statement of defense. Document production is a unique feature of arbitration insofar as it allows you to get documents from the other side that are relevant and material to the outcome of the case. I won an arbitration once thanks to documents obtained during in the document production phase. It was a construction arbitration, and we were the respondent, we were the owner and the respondent. The claimant had made a claim for additional costs, and we had made a claim based on defects. And in document production, we obtained correspondence between the other side, the opponent, and their subcontractors, which allowed us to prove our claim for defects and win the arbitrative entry. So that's something to also make the most of, and a unique feature of arbitration. In France, for instance, you don't have document production. All right, I can see that time is running out, so I will just conclude. There's a hearing, which is obviously a very important part. You can also make it very much of a difference on your case through cross-examination of the other side's witnesses and getting admissions from them, and then eventually the award and its enforcement, which is always something also to keep in mind. It's not the end of the game. Once you get the award, you need to enforce it. Thank you.
Thank you so much, Alexis. And I just want to emphasize the fact that he mentioned that this was ICC. There are many other institutions that administer international arbitration, and their timings and procedures may be slightly different. Even with ad hoc international arbitration, there might be some differences there, but this is a great guide you've provided for us, Alexis. Now, Victoria, can you kindly tell us, are there any differences in the various sectors you have experience in? For instance, is there a difference when there's international arbitration relating to finance or oil and gas or construction? And please, if there are, what are the main differences?
Thanks, Lauraine. So I suppose, as I mentioned before, one of the brilliant benefits of arbitration is that you really can tailor the process to fit your dispute and to suit the parties. Nowadays, as I mentioned at the outset, my work is increasingly focused on disputes in the construction and oil and gas sectors. And I would say that arbitration is probably the most commonly used dispute resolution mechanism within these sectors. And it's probably because arbitration is very well suited to the highly technical nature of these disputes. So in arbitration, as I mentioned before, you have the ability to appoint arbitrators with a technical background, which makes them the ideal decision makers for these kind of complex disputes. And also, secondly, in relation to the use of experts, is the party's ability to appoint their own experts within the arbitration process. This is a very commonly used feature that you might not have the ability to do within a litigation process. I think arbitration is also really well suited to the generally international nature of these industries. So what we often see on the kind of projects that we're working on is that a contractor entity is an international company that has come to set up in a particular country just for the purposes of that one project, whereas the project owner will be very much local to that jurisdiction. And so you can see in that sense that there's one party that has a inherent familiarity with the jurisdiction and probably with the local courts there, whereas the other party doesn't have that connection to the location of the project. And so arbitration allows you to avoid any perception of unfair advantage if the disputes were to be referred to the local courts. And secondly, in terms of enforcement, again, something that I touched on before, I think arbitration is much better suited to having to enforce an award internationally, and particularly if enforcement is needed in various different jurisdictions. You're quite likely to get coverage of those jurisdictions through the New York Convention. I suppose the other factor I'd just touch on in terms of why it's well suited to the construction and energy sectors is to do with confidentiality. So the confidentiality of arbitration depends somewhat on the institutional rules that are chosen. But generally, by and large, arbitration is known to be more confidential than court processes. And this is obviously really well suited to any industries where there might be trade secrets or other confidential information, which is relevant to a dispute. I would just add here as well, in terms of any other high-tech industries like computing or AI or tech generally, I think this aspect of confidentiality is obviously very relevant. I suppose the other area I wanted to touch on was financial disputes, which is something I did a bit more of earlier on in my career. And in this area, arbitration is probably a bit less popular, and litigation probably remains the preferred method of dispute resolution. To be honest, I'm not entirely sure what the reasons are for that. I think a lot of it is probably historic. Arbitration is obviously a newer method, which not all industries have adopted in the same way. Obviously, in financial disputes, there's less need for this kind of technical and subject matter expertise. So that's probably another reason why less financial disputes are referred to arbitration. I think the other reason why there's less use of arbitration in this sector is probably the ability and the ease of getting interim remedies. So with financial disputes, it's often quite important to get freezing orders or equivalent in place quite early on in proceedings. And while that's very possible in an arbitration process, it is arguably slightly more complex because often you'll still have to go to the local courts to request support for your arbitration. The final thing I just wanted to say is that this isn't always the case, and you can't necessarily generalize by sector, but for example, here in the Middle East, quite often we see finance documents having arbitration clauses, or if not an arbitration clause, then what's known as a unilateral options clause. So that's a clause where you've often elected to refer disputes to arbitration, but one party has the option to litigate. And I think for clients based here in the Middle East, especially international banks and other financial institutions, the importance of enforceability is probably what's driving this slight move towards having the option to arbitrate if needs be.
Wow, thank you so much. And just to add to what you said, I think one interesting twist to all this is that these are all areas that we can focus on and get some education in. So it's not only running in for the international arbitration masters, but we can do a master's in finance, oil and gas, construction. And these will all in the long run help us to be good international arbitration practitioners. So thank you so much, Victoria, for throwing some light on that. Now, Alexis, what are the fundamental differences between investor states and international commercial arbitration?
Well,
Alexis, just before you go, I just want to mention that if anybody has any question, please don't put it in the chat box. Put it in the Q&A section so we see it clearly, not the chat box. The chat box is for introductions, but please put your questions in the Q&A section. Thank you so much. Alexis, please carry on.
Yeah, I'll keep it very high level because I realize that it's already 15 to 5, at least in my time zone, and I want to leave time for questions. We could spend like hours just on this question, but in very broad terms, international commercial arbitration is arbitration between two or more private entities, right? You've got no states, no governments involved. It could be an individual or I guess more often corporations. When it comes to investment arbitration, you have to distinguish between two types of investment arbitrations. You've got investment treaty arbitration, which is perhaps the most peculiar form of investment arbitration, and you've got contract-based investor-state arbitration. What's the difference? In investment treaty arbitration, you don't have an agreement between the state, the investor, the corporation, the individual that's suing the state for can be many things, but I guess unfair treatment in the broadest sense. In investment treaty arbitration, the right to arbitrate against the state stems from a law or a treaty. I say a law or a treaty because particularly in Francophone Africa, you often have investment arbitration being provided for directly in the law. Earlier on, I told you about the sectors, and we've just talked about sectors actually. The sectors I'm mostly active in. Typically, mining is a sector where you have mining codes, and those mining codes sometimes provide for the possibility to initiate investment arbitration against the state, provided that you meet certain conditions. That's when the law itself, it could be also the investment code. The law itself is giving the investor the right to initiate arbitration against the state. There's also contract-based investor-state arbitration. So it's arbitration between a foreign investor, just like in investment treaty arbitration, and the state, but it's directly under a contract. So typically, concession agreement or a production sharing agreement in the oil and gas sector, you often have production sharing agreements involving the state. You can have a mining convention providing for an arbitration clause. So that allows the investor to directly initiate arbitration based on its contract with the state, and thereby avoid the jurisdiction of the courts, of the local courts. One thing to keep in mind, and that goes back to, I think, a comment made by Tosin, is that you should be creative and you should not go on automatic pilot. Meaning, sometimes you have different options, right? You may have a contract with the state that provides for an arbitration agreement, so you can launch arbitration under that contract. And you also have a treaty allowing you to launch an arbitration, typically ICSID arbitration. And so you have to choose whichever is best, depending on the circumstances of the case, depending on enforcement, depending on considerations of time and cost. It doesn't take the same time, it doesn't have the same cost to launch an ICSID arbitration versus an ICC arbitration. So I really insist it's worth taking the time to analyze your options. In certain regions, it's also multilateral investment treaties that are available and can allow you to launch arbitration. And to keep in mind that, as a final comment on this, that it's quite strategic how you structure your business before the dispute has arisen, right? You may want to do treaty planning when you invest in a given country as a foreign investor, and make sure you incorporate the company in the country that has a treaty with the host state. And then you can rely on that treaty to launch an arbitration later on if things go wrong. Be careful, and that's something that I had in a Western African country. A client came to me after the dispute had started between the investor and the state, and they wanted to move the company's place of incorporation in order to be able to benefit from a treaty. But that was after the dispute had started. Even though arbitration hadn't been launched, there was already a dispute between the state and the investor. And you can't do that at that stage. If you do so, if you change the place of incorporation, then you try to rely on the treaty between the country of the new place of incorporation and the government you want to sue. It will be considered treaty shopping, and you will be denied jurisdiction by the arbitrator. So arbitration won't work.
Thank you so much, Alexis. We have very little time and would like to take our questions as well. So I'll just like to skip to our last section where I give each of you a little time to just share 2 final words for people who are early career and mid-career lawyers. What can they do to ensure that they're able to pick up their careers in international commercial arbitration? And I'll start from Tosin.
Thanks, Lauraine. I'll keep it brief, but I think one of the key advice that I would give is to try and be open-minded, especially if you're quite junior and you're quite early on in your experience, because you never know what part of arbitration that you might like or which industry. And I do think that most experience is good experience. I think you mentioned earlier, Lauraine, even having a master's in, say, oil and gas, et cetera, can be useful here. And having those general people skills, which don't have to be limited to law. It could even be working in general customer service, etc. Those are all useful soft skill building activities that will be helpful here. And more generally, getting exposure to various areas of law and allowing yourself to find which you prefer. Especially when you're quite junior, you might end up doing quite a nice mix of work. Now I do a lot of tech related work, and it wasn't until I sort of allowed myself to explore different areas that I realized that that's an area that I wanted to sort of specialize in. So yeah, keep an open mind and explore as much as possible. Those are my words.
Thank you so much, Tosin. We'll move on to Victoria, and then Alexis will take us home.
Yeah, thanks. I think I would focus on networking if it was up to me. Obviously, you've got to focus on getting the right skills and building yourself professionally. But in terms of really tapping into the arbitration community, there's a number of professional associations within the arbitration space, as well as much more locally based arbitration clubs or members networks. And this kind of networking can open a number of doors. So you might end up being mentored by somebody, you might receive a referral, or just generally advance your career by speaking opportunities like this. So yeah, I think have a look into what societies and clubs are sort of active in your area in the field of arbitration, and look into getting involved with those.
Thank you so much, Victoria. Alexis?
Since I'm wrapping up, I will very much follow up on what Victoria said and give one example, perhaps more addressed to the mid-career participants to this panel. It's to try to get an appointment as arbitrator. The first appointments you get are usually for very small cases, and it's normal. So it's not for financial reasons that you want to act as arbitrator, but it gives you so much perspective on your job as an advocate. You start realizing what works and what doesn't really work once you're sitting on the other side of the table. So I started acting as an arbitrator about 3 years ago, and I really learned so much from those appointments. So if you can get appointments precisely through the networking that Victoria was describing, through making yourself visible, writing articles, picking a sector, picking a market, I recommend it.
Thank you so much, Alexis. Thank you so much to our panelists for sharing all your valuable knowledge. Before we move on to the Q&A section, as you realize from the flyer, you would get a certificate for participating in this program. So there's a link in the chat box. Please click it now and fill it in so you can have your certificates. Please fill it in immediately. Please don't procrastinate. Now we'll move on to the Q&A section, and because of time, I will indicate the people to answer each question. We might not all get to answer all the questions. Now, for the first one, I'm taking it from the bottom. For a country like Nigeria, which is heavily reliant on traditional litigation as a dispute resolution mechanism, how can a young arbitrator encourage clients and sometimes older lawyers to view arbitration as an alternative? I'll give this to Tosin. Let me read 3 questions before I move on. And then the next one is to Victoria. Given Victoria's observation on the complexities involved in obtaining a freezing order, how can parties in arbitration effectively navigate such judicial interventions without compromising the process as a true alternative to litigation? And the last one is for Alexis for this round. It says, with global supply chain increasing, complex contracts, often multi-party, how can expedited arbitration procedures balance speed and cost effectiveness with due process safeguards, especially when parties have vastly different resources? So we'll start from Tosin. We'll move on to Victoria and then Alexis.
Thanks, Lauraine. So I think just to recap, my question was for young arbitrators in Nigeria, how to sort of encourage people to get on board with arbitration in the region. I think it kind of links back to what Vicky mentioned about the various ease of arbitration, including efficiency, the time that you save, and the costs that you save as well. And I think one of the key points here as well is when you're engaging with international counterparties in contracts or in business, a lot of them might actually be more comfortable with international arbitration. They might be more familiar with these international arbitration rules, etc. And a key consideration for them will be, for example, enforcement under, for example, the New York Convention. And some of them might have a bit more distrust towards local litigation. So in that sense, if you can frame it from that angle, I think you can get quite a bit of uptake for arbitration in the region.
Thank you so much. Victoria.
Thanks, Lauraine. So my question was how parties can effectively navigate judicial interventions such as freezing orders without compromising the process of arbitration. I think one thing I want to focus on here is the seat of an arbitration and the importance that plays. So I think Tosin was going to come on to touch on this on our last question, which we haven't had time for. But when you're drafting an arbitration agreement, there's a number of different factors to consider. And the seat is one of these, and it can also be referred to as the place of the arbitration. But slightly confusingly, it's not actually referring to where the arbitration takes place, like where the hearing is. Instead, it's more of a sort of judicial home for the arbitration. And it's the laws of the seat of the arbitration which dictate which local courts will support an arbitration. And that's why it's so crucial to make sure you choose a seat appropriately. You shouldn't just be choosing the seat because it's the jurisdiction that the project's based in, or jurisdiction that one of the parties is based in. You should be making sure that you're aware of the arbitration law that's in place in that jurisdiction, and ensure that you've got the right methods of relief that you think you might need later down the track if a dispute did arise. Because that's going to dictate how easy it is to get things like freezing orders, or if they're even available in the first place. So that would be my advice.
Thank you so much, Victoria. Alexis.
Well, the question I got is from the other Victoria. Deborah, it's a great question. It's a long and one that would require a relatively complex answer, but I think it's a great point that Victoria is making. Essentially, she's saying expedited arbitration is not good for every dispute, and I think the answer is yes. Indeed, if you have a very complex dispute, expedited arbitration might not be a good option. It's made for small disputes, some relatively simple disputes, and I've actually seen that in an aviation case. Parties choosing expedited arbitration, then realizing along the way that it was not a good idea because the dispute was too complex, and they didn't want to rush the resolution of it. So you can always opt out of the expedited arbitration in the middle of the proceeding, actually, if you realize you might actually need more time. I had that as arbitrator. In fact, the parties had an agreement to extend the duration of the arbitration beyond the 6 months provided for in ICC expedited arbitration. So it's a possibility. And regarding Ukraine specifically, indeed, the conflict has had an impact and has increased the number of arbitrations, including outside Europe, by the way, because you've got like for instance, some LNG cargoes that have been diverted to Europe to replace the Russian pipeline gas. And so those LNG cargoes might have initially been intended for countries in Africa. And so the recipients of those LNG cargoes would then sue their co-contractor for breach of contract following the diversion of the LNG to another location.
Thank you so much, Alexis. We'll go in the same order. Tosin, Victoria, and then Alexis. So our first question for Tosin is, since an arbitral award is final, what options are available to a party who is not satisfied with an arbitral award? Then, Victoria, can you kindly let us know. I'll add these two. Is multilingual proficiency a requirement for serving as an international arbitrator? And what is the effect of AI on international arbitration? And then this question looks like one that should go to a lecturer. So it's going to Alexis. Why are arbitrators or arbitration institutions pro-commercial oriented solutions rather than pro-sustainability, irrespective of the provisions of the treaties? Probably this is an observation he or she has made, and they want some answers. Let's start from Tosin, please.
Sure, thank you. So my question was, given that an arbitral award is final and binding, what are the options available to a party who's not happy with the award? And I guess the strict answer is not many, because the arbitral award is final and binding. And as Vicky mentioned, the seat of an arbitration will typically govern the sort of procedural elements relating to the arbitral award, including enforcement, etc. So you'd have to sort of go to the jurisdiction of the seat. And most of the time, the only sort of way out of that would be if you're appealing the arbitral award on procedural grounds, for example, saying that due process was not followed, and similar sort of reasons. So yeah, the strict answer is not many, unless you can sort of show some sort of manifest error in the arbitral proceedings or challenge the arbitration agreement itself. But once that award is issued, it is mostly final and binding. And that is the benefit of arbitration as compared to litigation.
Thank you, Tosin. Victoria.
Thanks, Lauraine. So first, I think the question was about language skills as an arbitrator. I definitely don't think it's an absolute bar to being an arbitrator. It will just be one additional string to your bow if you can speak more than one language and enable you to practice in different languages effectively. In terms of how AI is changing arbitration, I mean, everyone has their own personal views on this, but for me, I actually think that AI has been a positive addition to arbitration. It's helping make the process much more efficient. And nowadays, there's also lots of processes which are popping up as a kind of alternative to arbitration, or something you might want to consider doing before arbitration, such as mediation, and settlement negotiations. And quite often these can be facilitated using AI tools. But in terms of arbitration itself, nowadays we're seeing so many virtual hearings, which is obviously saving a lot of time and money. And within those hearings themselves, parties are using more and more AI-based tools to kind of make the process more efficient. So, gone are the days where we all walk to court with pages and pages and piles of hard copy bundles. Nowadays, usually these are all uploaded onto electronic platforms, which everybody within the hearing room has access to, and which can facilitate, easily displaying particular parts of the relevant evidence that a party's referring to. I mean, there's millions of other tools that I could touch on, but translation tools and things like that as well. And also in terms of the arbitration hearing itself, the ability to possibly have AI transcribers within a hearing, I think is going to save a lot of money and time as well in the future.
Thank you so much, Alexis.
Yes, interesting observation from Olami Posi, right, on the, according to him, orientation of arbitrators and arbitration institutions. I think it's hard to make a general assessment of the orientation of arbitrators and arbitration institutions. If we start with the latter, arbitration institutions are relatively neutral insofar as they're only here to administer the process, in a sense, issue rules, but these are rules of procedural nature. The substance of the dispute will be addressed by the arbitrators. So I suppose the comments might be targeted at the arbitrators, perhaps more than the institutions. And the question of whether I lost the question on the chat, but I think there was a reference to sustainability, and so it seems like the question was whether the arbitrators are not sufficiently promoting sustainability and favoring. Sorry, I can't see the question, but anyway, favoring commercial interest. I think you've got obviously to study the arbitrator's background, right? And arbitration is very much the thing of the parties. So it's up to the parties to appoint the arbitrators that they think have the right orientation, to use the word in the question. And you've got arbitrators with different orientations. You've got some arbitrators that are notoriously pro-state, and others that are notoriously pro-investors. And at the end of the day, I think that's something perhaps to be taken into account. I don't think it's fair to say that generally arbitrators don't comply with the provisions of the treaty. The last thing I want to say is that if you're interested in this topic, which at the end of the day goes to the neutrality of international arbitration, there's a great PhD thesis from Amina Hassani. I don't know if it's been translated because it was already written in French, La neutralité de l'arbitrage international. And she studies how one can challenge whether arbitration is indeed neutral as compared to state court litigation.
Okay, thank you so much. So we're going to take our last round of questions, and the answers might have to be very brief, about 30 to 45 seconds. But then when we are done with those questions, please, panelists, feel free to type in the answers so at least our guests can get their answers. And please don't forget to fill the form for your certificate. The link is in the chat section right now. Just click it while you're listening, fill in the form so you get your certificate. So in the same order, Tosin, someone wants to find out that, is it possible to go for arbitration in all disputes so as to do away completely with litigation? And then Victoria, it's a two-pronged question from Ruhama, says that since parties characteristically appoint arbitrators, how then can such an arbitrator be expected to remain unbiased? And please explain more on emergency arbitrator. I think we can give that answer written, but the first one, we can look at it orally. And then the last one that Alexis will tackle for us is, since you're a lecturer again, for a project topic on international arbitration or arbitration in general, what did you advise the law students in final year to write on? I think they are looking for some trending topics that will shoot them into the limelight. So please help us, Alexis. So we start from Tosin.
Thank you. So my question was, can arbitration be used in all disputes so as to do away with court litigation? And the answer is unhelpfully that it depends, because in some jurisdictions there are certain subject matter that have to go through the local courts. For example, here in the UAE, there are certain labor disputes, for example, that would have to go to the labor courts and the labor tribunals here. So it does depend. But if the dispute is arising out of a contract, typically you can use arbitration to resolve disputes, but that would need a bit more analysis on a case-by-case basis. So we can't say blanket that arbitration can be used for every single dispute.
Thank you. Victoria.
Thanks. So the question was, how can arbitrators be expected to remain unbiased when they've been appointed by the parties? And I suppose the important thing here is to just draw this distinction between a party appointing an arbitrator and that arbitrator being seen as that party's arbitrator. There's a lot of emphasis put on impartiality and independence within the arbitration process. It's of paramount importance, of course. And so at the outset of proceedings, all of the arbitrators that have been appointed will be expected to sign a declaration of independence and impartiality. And that's very much the basis on which they're conducting the arbitral process. And going forward in the arbitration, I think it's just, it's important for both the parties and the arbitrator to not do anything that would put themselves in breach of these requirements. So, the arbitrator appointed by one party shouldn't be seen to be, talking separately with that party or, favouring their arguments in particular. So it's very much just an appointment by the party, and then that arbitrator sits on the panel as independently as the other two arbitrators do.
Thank you, Victoria. Last but not the least, Alexis.
Yes, I cannot see the question, but I understand it was basically one asking for suggestions on relevant topics, correct?
Yes. For a final year project, or probably you can add masters or PhD, something to look at in international arbitration.
I think it would be I would recommend linking international arbitration to certain sectors. We've talked about sectors quite a lot today, but it is interesting to see the specificities of mining arbitration or energy arbitration or even construction arbitration. It's definitely an area that I would explore. I mean, if you take mining arbitration, the role of mining in the energy transition is becoming more and more clear. So it's clearly an area where there are avenues to explore. When it comes to energy arbitration, we've touched upon one example, which is the impact of the Ukraine war, force majeure claims, and the likes. When it comes to construction arbitration, you've got the energy transition as well. Offshore, onshore wind farm disputes, for instance, do give rise to specific types of disputes and have an impact on how you conduct your arbitration. So yes, my recommendation would be perhaps pick up a sector of interest and see what specificities are associated with that sector for international arbitration arising in the sector at issue.
Thank you so much, Alexis. Thank you, Tosin. Thank you, Victoria. I'd like to round up now with a few points that you mentioned that we can take note of. I believe a lot of us on here are looking forward to kickstart or ramp up our arbitration practice. And one of the ways to do that, first of all, is to become visible. Because it's not like the legal practice where you are associated to a law firm and the law firm just advertises. Usually, even when you're associated to a law firm, international arbitration, you should have some experience on your own, which carries you as a practitioner. So please network with people on LinkedIn. We had about 200 people on here. If I were you, I'll connect with each and every one of them because they are all people who are interested in international arbitration. Also, when you can write papers, there are so many opportunities for writing of papers. Institutions have put out calls, or you can personally put together a paper and publish it. Who knows? People will find your name through there. Also get the requisite certification. It's not compulsory, but it helps. Tosin mentioned CIAB. ICC also does some training. Just Google it, ICC training, CIAB training, arbitration training, and a lot of different things would pop up. With regards to the courses you can do, probably masters or PhD or short courses that can help you in international arbitration practice, everything qualifies. So oil and gas, finance, construction, even family. There's a family law also in there. So you can do that as well. And someone also asked about the difference between arbitration and mediation. In mediation, we have a neutral third party who assists the parties to resolve their disputes. In arbitration, the neutral third party sits like a judge and does not get involved with the disputes, but helps them to solve it, not in the sense of discussing it with both parties. And finally, I'd like to mention that this has been a great webinar. We'd like to thank all the organizers and the panelists for joining us. We'd also like to thank you for coming to join us as well. I know you didn't see the names of the attendees, but most people introduce themselves in the chat section. So just scroll through that you will see their names on there. Don't forget to click on the link that helps you to register for your certificate. And I'm the host for an arbitration program called the Arbitration Pitch as well. So if you like to learn more or see more arbitration practitioners on a weekly basis and learn what they are doing, you can join our channel and grow with us. Thank you so much, and do have an amazing day. Thank you. Thank you. Bye, Victoria. Bye, Alexis. Bye,
Thank you.
Tosin. Thank you all so much.
Thank you for having us.